Welcome to our Title VI training focused on an introduction to Title VI and its historical context, brought to you by the Shared Title IX and Title VI office. As we begin, we want to ensure everyone has an understanding of how adhering to Title VI requirements supports a welcoming campus community. As an institution of higher education, we have a number of cultural values and expectations that align closely with Title VI regulations. For example, we expect all community members to foster an environment of respect. We encourage collaboration and constructive engagement across our differences, and we value acceptance of all community members, regardless of their background or beliefs. As we move into legal obligations, you will see how they are consistent with our institution's cultural expectations. Title VI of the Civil Rights Act of 1964 prohibits any program or activity that receive federal funding, including virtually all colleges and universities, from discriminating against anyone on the ground of race, color, or national origin. Race may refer to a person's actual or perceived race or association with a person of a certain race. Color may refer to a person's skin pigmentation, shade, or tone. National origin may refer to a place where an individual or their ancestors are from, as well as any shared characteristics of that place. National origin includes shared ancestry, which refers to biological, familial, or genealogical lineage, as well as ethnic characteristics, which refer to socio-cultural traditions and identifiers that may or may not map onto national borders. You will note that Title VI does not specifically protect against discrimination based on religion. However, there are times when religion overlaps with national origin. For example, when Jewish, Muslim, or Hindu students face harassment based on shared ancestry or ethnic characteristics. In these instances, Title VI protection for genealogical lineage or sociocultural tradition has the ancillary effect of benefiting certain religious traditions and beliefs. The specific text of Title VI has not changed in over 60 years, but over time, the federal interpretation of these regulations have expanded, and guidelines for applying the regulations change depending on political priorities. As a federally funded institution, Stanford must comply with Title VI, ensuring it is a non-discriminatory space for students of all backgrounds.
Let's delve into the historical origins of Title VI. The 1964 United States Supreme Court case, Brown v. Board of Education, combined several lawsuits brought by Black families challenging state laws that required or permitted segregated public schools, arguing that such segregation was inherently unequal. In Brown, the Supreme Court held that racial segregation in public schools was unconstitutional because separate but equal violated the Equal Protection Clause of the 14th Amendment. Title VI built on the legacy of Brown by prohibiting racial discrimination in any program or activity receiving federal funds, extending Brown's desegregation principle beyond public schools to all federally funded education programs and activities. Congress enacted Title VI to address persisting issues of segregation and discrimination. At its core, Title VI was designed to ensure that education institutions fulfill their responsibilities to ensure educational opportunity for all students, regardless of their race, by remedying racial discrimination, including harassment, which is considered a form of discrimination. Initially proposed by President John F. Kennedy, Civil Rights Act of 1964 was signed into law by his successor, President Lyndon B. Johnson. In the years that followed, Congress broadened the scope of the act and enacted additional civil rights law, including the Voting Rights Act of 1965. The Civil Rights Act was passed at a time when access to transportation, restaurants, and other public facilities were severely restricted for people of color. Jim Crow laws prohibited Black people from attending colleges and universities, and segregated institutions of higher education were often underfunded and lacked resources. The Act aimed to end segregation and discrimination, and to ensure equal access to public spaces, education, and employment, and federally funded programs. Title VI of the Civil Rights Act of 1964, which prohibited discrimination on the basis of race, color, and national origin, came 8 years before Title IX of the Education Amendments of 1972, which prohibited discrimination on the basis of sex.
Thank you for your time and attention to this training. Feel free to reach out to us via our website, titlevi.stanford.edu, or our email, tvi_outreach@list.stanford.edu if you have any additional questions. We also encourage you to review the OCR fact sheet, Harassment Based on Race, Color, and National Origin on School Campuses, and the Freedom of Expression website.